on global health law and governance, the need to think about non-communicable diseases in the post-pandemic period. The speaker for the session is Professor Sarah Steele. She's a Deputy Director of the Intellectual Forum, Jesus College, Cambridge. She's also associated as Senior Research Associate in Cambridge Public Health, University of Cambridge, School of Clinical Medicine, Cambridge University. We're delighted to have you here, Dr. Steele, and now I invite you to present your talk on global health law and governance. So over to you, Dr. Steele.
Thank you so much for that introduction. I am absolutely delighted to be here talking to you today. And I think it's a really rare opportunity, I think, to reflect on global health law as an international community in this kind of way where I'm sitting here in Cambridge and talking to you wherever you are. I know many of you are in India, but I'm sure there's other people around the world joining us as well. And I want to take this opportunity to kind of dissect and explore where we're going in the future. Today, I'm really going to kind of move forward from the fact that COVID-19 attracted extensive attention. Quite frankly, it placed communicable disease and the role of law and governance in responding to those at the forefront of much of our attention, something that happened quite rarely outside of just law faculties and clinical schools. For the first time, really, the public understood and had seen global health law and governance in practice. Numerous laws and extensive resources have been adopted and placed around the world in an attempt to address this pandemic. But COVID-19, despite all its attention, do you think it's now the leading cause of death? Most of you are in India. What do you think is the leading cause of death in India? Put it in the chat. What do you think is the leading cause of death? Don't Google it. Don't look it up on your phone. Put it in the chat. What was your knee-jerk reaction when I said to you, what's India's leading cause of death right now? I'll give you a moment just to put it in there. Road accidents, somebody said. There any other guesses? Heart attack. Yes. So others have said low breathing rate amongst older people, untimely interventions of healthcare services, air pollution. All of these guesses go to some of the top causes of death, but it is in fact heart disease. When we look at the leading causes of death in most countries, most of them, even despite the COVID pandemic, remain non-communicable diseases. Here in the UK, in 2021, so the peak of the pandemic for us, it was only the fourth leading cause of death, COVID. In the USA, you see it fall also behind heart disease and cancer. What is clear from those data are that absolutely communicable diseases matter, but non-communicable diseases, those things that are these killers of us, are not often the focus of our attention. Many expected the pandemic to shift the leading causes of death, and while I'm not saying that there hasn't been some changes in terms of what kills people, it is notable that NCDs remain at the top. While international data are still out on how significant COVID-19 has been, we can look at those individual country level data. We can look at different cities and provinces, and what we see is a continuous thing. It's that the top killers are things like heart disease, stroke, cancers, chronic pulmonary disorders, these sorts of things. Importantly, also diabetes. We know that these top killers are driven by certain things. We know what the risk factors are in public health. And those risk factors are things like high blood pressure, smoking, obesity, air pollution, which somebody mentioned, alcohol, a lack of nutrient-rich foods like fruits and vegetables in our diets. And these are all things that are alterable. They're all things that we can change. The important thing about this is that while public health specialists are easily able to acknowledge that we know what these causes of death are, we know that some of these are absolutely a result of demographic changes, of aging populations. Many are actually preventable. Have I actually paused? I notice I'm freezing. If for any reason I drop out, I will come back.
We're able to hear you.
Good. I may pause a little bit. Our internet's disrupted. I'm getting those Zoom meeting messages. But I just wanted to say, we know that many of these are preventable, right? The quality of our air is something we can impact. The quality of our diet and our lifestyle factors are things that we can affect. And while the acute phase of COVID-19 has overshadowed many other health issues and highlighted the role of law and governance in responding to communicable disease, I want to kind of spend a lot of this session looking at what we can actually learn from this to address these non-communicable diseases and how we can capitalize as lawyers, as those interested in law and governance in the immediate period to influence our local, national, and international responses to improve health overall. We know issues like diabetes are a major expense to national governments and healthcare systems, but they're also an expense to us. They impact our quality of life, they impact our families, they impact our ability to be functioning within economies, going and working at universities. They cost a lot of money. They cost money not just in terms of access to medicines and healthcare systems, but they cost us in terms of GDP. They cost us in terms of the overall happiness quotient of our populations, and they keep growing. They're growing so quickly, and we firmly know that diet and exercise play a role. And what's important is that we know that poor diet and particularly malnutrition are major contributors to our global burden. In 2017, so before the pandemic, 10 to 12 million deaths alone were attributable internationally to just solely dietary factors connected to excess salt, added sugar, and trans fat consumption. So all things we've added to our foods. The human suffering caused by those illnesses is especially acute in low and middle income countries, where there is a coexisting situation of overnutrition, so excess, too much sugar, too much salt, overnutrition, too many calories, happening simultaneously to undernutrition, where people aren't getting enough food. These pandemics coexist within the same countries. And what that means is that while non-communicable diseases are responsible for the majority of deaths worldwide because of overconsumption, we simultaneously need to pay attention to our whole food systems and our whole systems. What I want to kind of say from a public health perspective before I get to the law is it's very clear that we've got things like energy balance completely wrong to date. It's saying that we're not doing enough. At the present time, we responsibilize, we make people individually accountable in our approaches for the amount of calories they take in versus the amount of calories they put out. The message that we give is that you are responsible for what you eat and what your children eat. And what my message is going to be tonight for you, is that it's not quite that simple, and that law, governments, and regulation have a role, and that the international community and global health law and governance need to take that globalized view. And where I want to kind of start is just to say that while COVID-19 diverges from major NCDs in that we can see it has a clear clause, we can see its rapid transmission and effects, and we can see that there is a lack of overall effective curative treatment for COVID-19. It teaches us, though, that there are common risk factors to communicable and non-communicable disease. We know that those who were older suffered more and died more frequently from COVID. Those who were male in sex, those who came from ethnic or minority racial groups, those who were obese, were in poverty, or smoked, all suffered the consequences of COVID at higher rates. And as such, what we recognize is that there is a fundamental thing that sits common to communicable and non-communicable disease that we must address right now. And that is that these are the products of systemic factors. They're the products of the systems that we are in. And alongside those individual factors that we've suggested around changes to your diet and exercise, it's really critical to address the upstream factors. It's really critical that we address law and policy in our responses. When I work in the clinical school, I work with so many people who talk about interventions around plate size. If we change the amount people are eating by changing the size of their plate, will cure obesity. What I want to say is that's only a tiny, tiny piece of this picture. In fact, law and policy shifts are important. They are critical, and individual choice models aren't sufficient. So what then can global health law do? What has it done? What is it doing in the future? Many of you may not even know what I mean when I say global health law, so I want to pause for a second to define it. In his 2014 treatise, Professor Gostin defined global health law as the study and practice of international law, both hard law and soft instruments, that shapes norms, processes, and institutions that attain the highest standard of physical and mental health for the world's population. This means that we are looking to both binding and non-binding instruments. We look to things like the framework of the World Health Organization, its constitution, and we look at the interaction of different standards. We look at treaties like the Framework Convention for Tobacco Control, which I'll talk in a moment about. And we look at other bodies of law outside just the WHO's immediate responsibilities. We look at human rights law. We look at international humanitarian law. We look at international environmental law. We look at international trade law. We look at intellectual property law. We look at investment law. All of these things all function in this area. Now, some of you may have heard during the pandemic different terminologies, and I want to be really clear. A lot of people talk about international health law. International health law is something a little bit different. It was used in the 20th century in connection to kind of cross-border epidemics, and it sought to use these kind of epidemic control mechanisms and handled health in the context of defense ministries and immigration control to try and stop the spread of disease from location A to location B a lot. It was deeply rooted in the notion that poorer countries bring diseases to richer countries, and it was therefore deeply problematic. It was deeply linked, I want to say, to colonial structures and colonization. It was grounded in deeply troubling and problematic ideologies. And so in the 1990s, we saw an accelerated shift to speak of the global. Part of this was connected to pushes in human rights. Another part of it was connected to the notion that the whole planet faces issues, not just particular nations. And that there is the growing influence of non-state actors in this sphere. Global health, therefore, reflected the consequences of globalization in terms of both the health field, but also the increasing role and powers of different actors in terms of law and governance. Proponents of the notion of global health law really emphasized that it was a field with a center that shaped normative content. the protection of health became that central function in the face of conflicting interests, in the face of conflicting bodies of law. It was an attempt really to overcome the fragmentation of international law in terms of all those things that I've mentioned: human rights law, trade law, investment protection, humanitarian law, environmental law, and more. It sought to move beyond that international health law as being this very narrow thing concerned with pandemics to talk about creating a normative basis for international responses. And it sought to emphasize that what we were trying to do with these legal arrangements and frameworks was to enable all people, wherever they are, to realize their right to health. In light of this, I'm working from the position, and everything I reflect on in the coming section, on the fact that global health and human rights are complementary. They're entwined and they are connected to the advancement of physical, mental health, and therefore social well-being as well. And that is throughout the whole world. And that therefore addressing non-communicable diseases alongside communicable diseases is critical to improving health for all. This isn't a new view, but I think it's really important to say, when we sit as an increasingly fragmented group of societies who've taken very national approaches to things like vaccines, where some countries have over-purchased medicines, over-purchased vaccines, acted in their national interest to the detriment of other countries. In a situation where global health law has been focused on new pandemic treaties, where we're talking about the TRIPS agreement, so intellectual property law at the international level, and how we can reform that to get better access to vaccines and medicines. Against that background, I want us not to forget that the big killers are also NCDs. And therefore, undoubtedly, as we take this story of global health law and human rights forward, NCDs have to fall within that. And they require us to look to slightly different questions and slightly different shifts and changes to deliver on that human rights promise. Now, of course, I just want to pay attention to the fact that global health law is closely linked to human rights, in part because of its history, right? In 1946, the WHO's constitution was the first international treaty to recognize the right to health. It predated the Universal Declaration of Human Rights by only a few years, and therefore it fed into that and also the International Covenant on Economic, Social, and Cultural Rights. While we saw a lot of movement around health and human rights in the 1990s as a consequence of the AIDS pandemic, it is very clear that health and human rights are entwined, and it is very, very clear that the response to NCDs at the moment needs to draw from the obligations in those international human rights documents. In 2017, states gathered to prepare for the third UN high-level meeting on NCDs, and they restated their commitment to take bold action to accelerate process to reduce premature mortality due to NCDs by a third by 2030 in alignment with the Sustainable Development Goals. What happened at that high-level meeting of the UN, now 5 years ago, was an explicit acknowledgement that there was a role for law and legal expertise. Alongside calls for public health evidence, there was calls for technical advice and case studies of how to address legal issues. This came about because in exploring the relationship between non-communicable diseases and law, between things like those dietary factors and smoking, what became clear is that the conventional logic of consumer choice was being pushed by industry, and that actually states, if they were going to meaningfully reach that UN target, would have to take a regulatory intervention. But there continues to be industry-led challenges using different mechanisms in trade law, in intellectual property law, in these sorts of areas that dissuade states, that have what we call a chilling effect. They stop states wanting to take meaningful regulatory and legal action to reduce NCDs. And I'm going to set these issues out in brief for you. Obviously, most of you are aware that there is kind of one core health treaty at the moment. There is one core thing we know has worked. So I'm going to start there. I'm going to start with the positive before I go on to all of the issues we face. I'm going to give you some hope before I kind of put all the problems out there. And that treaty document, the first treaty negotiated under the WHO is the Framework Convention for Tobacco Control. This was the first legally binding treaty, as I've said, and it calls on states to adopt a number of measures. If you look, for example, at Articles 6 to 14, you see measures that are attending to demand. Those things about who's trying to buy this, what the demand is. And if you look at sections 15 to 17, you find things around the supply, if you look at Articles 15 to 17, and also the additional protocol. I'm just going to summarize those in broad headings to say those measures include things like price, which can be affected through taxation. And they do things about putting disclosures on product packaging and labels. They also create provisions on the supply of tobacco to minors, prohibiting it. And they talk about measures to address the illicit trade. Because of course, when we tax things and the price point goes high, it does incentivize crimes around the illegal and illicit trade in these products. So the idea here was to have a comprehensive treaty document that sought to reduce smoking-related non-communicable disease deaths, that was grounded in a huge body of public health research and other evidence that allowed us to create a dynamic, evolving treaty response. It was robust, and it led to significant implementation and measures around the world. Its significance cannot be underplayed. But as many of us know, there was a number of disputes that countries faced when trying to implement the provisions of that under trade law and under intellectual property disputes. My country is, of course, one. Australia was on multiple fronts defending plain packaging laws. Now, I want to make clear a few things, and that is that there is no similar treaty on other aspects of non-communicable disease risk factors. There's no similar treaty on alcohol. There's no similar treaty on dietary factors like food and sugar-sweetened beverages. While the World Health Organization in that high-level meeting acknowledged things like with the fact that we need to consider marketing restrictions, especially for children, if we're going to address pediatric obesity, that we need to reduce product availability for those very worst products that contain high levels of added sugar, high levels of trans fats and the like, in order to reduce consumption of these. We need to place restrictions on things like advertising times and sales, including age limits. And they also have pushed for things like soda taxes. We see from these, and we learn from the lesson of tobacco, that such measures, especially without a treaty in place, may lead to issues of trade disputes and also issues around trademark protection. Let me set this out for you. Absolutely, most of international trade law centers on the idea that trade liberalization is desirable. It's something that allows for the efficient allocation of resources. The idea here is that by increasing this wider competition, it will lower prices and consumers therefore get better deals, states benefit, and we get more access. Public health studies, time and time again, though, have shown that there is a link between trade liberalization and obesity. Studies in the Caribbean, in the Pacific Islands, have shown that trade liberalization, trade agreements, increase the energy density of food, that is the number of calories it has per gram, and also increases nutrient poor foods, so things that lack vitamins and essential micronutrients, and that has major impact on populations. Women particularly get more obese and overweight, and diabetes increases in that population. Trade law absolutely recognizes that member states can involve a public interest exemption. So when they see these things happen, they can pursue public health interventions. They can do things that are protective of public health. In order to control the movement of goods, though, disputes come up time and time again, pushed by corporations. Multinational corporations try to address those public health measures through a number of strategies. Obviously, one of those core things is lobbying, right? So at the point of trade negotiations, we see extensive involvement of industry trying to influence what the shape of trade provisions takes. But we also see multinational corporations come in when regulation does happen, where that public interest, that public health protection exemption is put in play to pursue disputes that basically derail the ability of countries, the ability of provinces, the ability of states and territories to address the public health issues that their populations face. And often countries, states, provinces face these on multiple fronts simultaneously. So of course, there is, as I mentioned, there's trade disputes under either the WTO's rules or under the EU rules, but there's also often where there's plain packaging, defense of trademark, and also often constitutional challenges at the national level using provisions often placed within national constitutions for the protection of free speech. So a country that tries to do something about an emerging public health issue may find itself in arbitration at the international level, may find itself in disputes in different areas and regional bodies, and simultaneously taking us forward in its national courts. That's expensive and it's resource intensive. Solicitor General's offices or the akin in relative countries, I know they all have different names depending where you are, but the legal services within government, within the executive and within that are stretched as they try to address these provisions. They are costly, and that dissuades many countries from taking legitimate action to address the issues that they face. And part of that is because the party arguing about the public health concerns they face has to justify derogating from the principle of free trade and must present the evidence necessary that shows that it's necessary to achieve the objective they're pursuing. Industry, therefore, often funds other states to take countries into disputes. And we find, quite frankly, that it's mainly high-income countries that have addressed these challenges to date. Beyond the kind of lobbying issues, we've seen disputes over tobacco plain packaging, as I mentioned. We've seen disputes over product and ingredient changes. We've seen disputes over soda taxes, and we've seen disputes over alcohol provisions. I'm going to set out some of those. What we know is that, for example, in the 1990s, tobacco companies robustly acted around the world. For example, they claimed Thailand's proposed cigarette ingredient disclosure legislation violated the TRIPS agreement, and that Canada and Australia's responses violated intellectual property rights under TRIPS, but also impacted on NAFTA and led to trade issues. When the alcohol industry faced similar strategies to reduce consumption, it threatened WTO disputes against Thailand if it adopted a ban on advertising of alcohol. It also argued that when the Scottish government here in the UK tried to legislate on minimum unit pricing, that was a problem for technical barriers to trade. In Canada, one of the provinces there, one of the territories there, sought to adopt particular warning labels on bottles, and the industry supported a range of challenges that suggested that violated various trade law provisions. This comes about in part because there is a vagueness in trade agreement text. that has historically produced variable interpretations for different dispute panels to evaluate whether a government's proposed course of action actually risks whether there will be this kind of trade-related legal threat. The word necessity is the one that I'm thinking of here. So necessity in the Thailand case that I talked to you about in 1990s when they tried to ban tobacco imports, it was constructed very narrowly. And it was ruled that there was an insufficient justification provided for the ban as part of comprehensive tobacco policy. Thailand actually had to reverse its ban and reduce back tobacco excise duties. In 2011, Samoa had to actually step back on one of its provisions, which sought to kind of address fatty meat cuts. So the WTO members actually questioned the prohibition of a single food item as necessary to address the complexity of obesity. And there are other cases where that kind of narrow notion of necessity has been prohibitive of states being able to engage in these kind of public health measures. That said, there are other cases where necessity has been interpreted more progressively. There is the Brazil tires case, basically where a more comprehensive approach was adopted. And that has led many states to not quite know where they stand, especially around obesogenic food and drink environments. Because we don't know how that necessity word is going to be interpreted by different panels and different bodies, it leads to variability that's disconcerting to states. They don't quite know what disputes they're going to get drawn into, and so they tend to be cautious, especially in resource-poor times. But also because there's a lack of case law specifically on obesogenic foods and drinks and on alcohol policy, there's significant uncertainty around outcome. That uncertainty dissuades states. It has that chilling effect. But also we know that multinational corporations actively, in their own words, in emails I've got under freedom of information laws, we know they exploit that uncertainty, but they also exploit public discourse. They exploit changing public opinion. And they want to move the discussion from health and human rights to those very technical points. So the tobacco industry widely claimed, for example, when Australia tried to pursue plain packaging legislation, that it was in violation of their intellectual property rights. Essentially, what they kind of tried to do was to use this tactic of changing the discursive reality of saying, you're infringing my rights in this process. And the purpose there was to kind of have that chilling regulatory effect, to dissuade other countries from pursuing similar public health legislation. And so what we find against that background of vagueness, against that background where the necessity of certain provisions to challenge a public health issue is difficult to prove, like Samoa with trying to ban extra fatty cuts of meat from import. What we find is that we need standards and evidence, and we need some clarity. We need robust public health evidence, absolutely, and that's what I work with colleagues on, but we also need robust rules and we need very clear instruments, which we just don't have around this yet. We saw success in the case like tobacco, that a treaty could make a huge difference, where it set out standards, guidelines, and particularly legally binding provisions that gave governments confidence when they adopted health measures, and also created impetus that made states realize that they could overcome trade-related concerns and legal threats. In the sense that we need to somehow indicate what necessity is, this is a really important thing for us to consider and contribute to as lawyers. International health instruments could support the assertion of health objectives more strongly to the WTO. It could create confidence in low and middle income countries to actually feel that they could regulate in a consistent and coherent measure, like, for example, the ways that we have done around the Framework Convention for Tobacco Control, where we've talked about price, illicit industries, and things like that. Australia certainly drew on the framework, the FCTC in its WTO defense. So we know that Framework Convention had influence in a trade dispute. We are at a point where we can meaningfully consider the shape of international responses to health law. We are discussing pandemic treaties. And what I'd say is, as we start to discuss the perspective for international instruments to address health concerns, we shouldn't just limit our focus to pandemic treaties to address future pandemics like COVID-19 has been. We should also consider the position of treaty documents to actually address the issues we face, like heart disease, cancer, etc., and meaningfully attend to non-communicable disease factors. And we must also, in our debates over reform of our intellectual property situation, as we discuss around vaccines and access to medicines, where we've clearly had major highlights of the issues we face, as we consider whether we change those regimes around intellectual property, we also need to discuss trademarks. We need to not just be concerned with discussing patents and patent exemptions and all of these kind of things. We need to also talk about whether we are happy with these continued trademark disputes over things like plain packaging, food, beverages, etc. One thing I work on, and I realize I'm coming to the end of my time, I want to give you some space for questions. One thing I work on is looking at the fact that to date, a lot of impetus for health treaties has been impacted by the fact that industry representation on government trade committees is actually limiting us here. We have a lot of closed and hidden influence that has dissuaded governments from making decisions and subjected many of our policymakers and decision makers to the pressure of the industry, the major players here. At the national level, we need to look not just at technical capacity building and interdepartmental collaboration and cooperation, but we also need to look at the link between getting health agencies and legal bodies to talk about trade. We need to have health players at the table, and we need to think about industry influence and how we're going to make transparency and openness priorities so that we don't get those hidden chilling factors happening alongside the more open chilling factors like arbitration, like national legal disputes under constitutional provisions. In fact, it is really important that we have key health and trade lawyers present in these negotiating forums. It is imperative that law studies start to look beyond just medical law and ethics, in my opinion, in this post-pandemic period to train us in a global health law and governance. I only came to global health law in my master's. I'd never heard about it when I studied undergraduate degrees because it was seen as not something very essential. It was seen as something not important for us to study as students. We studied criminal law. We studied constitutional law. We studied human rights in this kind of hand-wavy way where health was mentioned, but in passing. I never studied global health law, but what this pandemic should have proved to you, and what I've said today about non-communicable diseases, is that the future health of all of our populations is contingent on an effective response. And that draws on our knowledge and brings together our appreciation of other areas of our legal study, like trade law, intellectual property law, environmental law, and the like. That what we need to do is not just strengthen international institutional capacity, but place well-trained lawyers at the heart of that. We all need to be learning about health interests in terms of trade law. We all need to be learning about the implications of trademarks for public health regulation in our local provinces and in our national fora. And we need to be able to provide technical assistance to governments, both in our own situation and around the world, and share the knowledge, share the evidence, share the technical assistance, and share the impetus to address these top killers. We've had a hugely ambitious approach to this pandemic in many respects. We've had many failures, absolutely, but the COVID pandemic has shown that global health governance can have a role. We have a rare window of opportunity for public health actors to work with lawyers to push for social, environmental, and economic change, and to build support for a growing body of global health law in its own right. This requires us to collaborate. It requires us to offer each other technical assistance. It requires the WHO to be able to coordinate that collaboration and those technical assistance, in my opinion. It also requires us to look at how we fund and support other countries that wish to pursue those really critical changes to their laws and to push public health interest forward. It is my belief, as you've probably taken away as a scholar, that we actually need to have an agreement on non-communicable diseases alongside any pandemic treaty that we pursue. A well-framed legal argument in any arbitration or international dispute over public health provisions is going to require us to have clarity in terminology and in terms of tests like the necessity test, and require us to engage in evidence sharing. And that requires us to move away from these nationalist pulls we've seen in the last 2 years. We must reverse this to take a collaborative response. If we're going to address the fact that the top killers on this planet right now are actually not what we think they are. They are heart disease, they are cancer, they are stroke, they are chronic pulmonary disorders. All of these issues require us to take action, and this action is not going to be apart from our communicable disease strategies. It's not going to be apart from our addressing air pollution and climate change. These things, planetary health is human health. And so robust, collaborative, technical responses are necessary. And on that basis, I kind of claim for all of you that I think global health law and governance have a central and critical place in addressing all the social and community issues we face. That absolutely global health law is connected to human rights law, but it's also connected to a wide range of other bodies of international law, as well as national legal regimes, constitutional laws, and the like. I hope that all of you see, even if global health law has not been part of your curriculum, that it is a critical thing to learn about. And on that basis, I'd love to collaborate, I'd love to work, and I'd love to push this for all of us going forward in the future. Thank you so much.
Thank you, Dr. Steele, for such a wonderful lecture. I mean, I would see it very optimistic, and in fact, an appeal that the interlinkages between international law and global health would produce some policies or frameworks would be binding to various nations. I mean, that's where the optimism starts from, because I will slightly take your concern to some of the uncomfortable situations. I remember in US during Obama's presidency, there was a demand for a universal healthcare bill, and the Senate could not pass it on. So, I mean, when the libertarian economics argue that increase in public health expenditure would lead to rising inflations, in the long term, I don't know how far these international legal regimes would create a measure to ask or demand states to continue spending more and more. When you see, I mean, the budgetary control over defense and other sectors going, it's increasing. If you see the defense expenditures all over the world and the kind of support they receive, it's increasing. So less and less expenditure on poverty, elevation policies, health, and decreasing public employment. So, I mean, within that scenario, I do get the point that, in some ways, because that was a broad brushstroke that you painted in terms of, some of the early difficulties in defining the scope of the discipline itself, global health, and the colonial history behind that in 18th century, 19th century. And if you look at one of the problems that we see in terms of thinking about international within the global health to an extent was that you replicate what is happening in France, epidemic control measures, in some other country, for example, Germany. So using those measures and trying to produce an international regime that happened in 19th century when we look at how to contain epidemics and all, the kind of surveillance and all. And even today, I mean, if you look at the debates, I mean, Georgia Gambon has pointed out a lot that rather than thinking about the public health of the communities at large, it's more about state control, surveillance, and other things. And there has been a debate on that. So, well, I mean, there are a few points which I was quite intrigued listening to, I mean, in terms of the desirability of trade liberalization. I don't know how far that is going to improve public health system in terms of the arena of the international, because we have seen since 90s that whenever the demand for liberalization of economy has happened, it directly led to the reduction, again, of the social security expenditures in. Now, one of the things which I was also thinking about that if we look at number of significant deaths in India, apart from non-communicable disease, here you have actually brilliantly pointed out in terms of the conflict that the states might have with multinational corporations, pharmaceutical industries, so lobbyists, interest groups, powerful people, powerful corporations. But if you look at, for example, the number of deaths related to malnutrition in India, in some of these developing states, Bihar and Uttar Pradesh, or you look at the number of deaths that happen during childbirth, especially in the least, backward states in India. There, I don't know, I don't understand why the domestic states in their own territorial jurisdictions are not willing to increase public health. And one more thing, I mean, this all is coming from your talk. And one thing which I was wondering is, does international law also think about the skill development and training of public health workers? Because as far as India goes, it has always been a debate here that the infrastructure for maintaining such a large pool of public health workers is something which is very difficult. Looking at the population of these countries, I mean, I'm talking about countries of Asia, Africa, Latin America. Don't know about Europe so much, but that's how. So I see these uncomfortable situations and circumstances, and I don't know how then to relate to the optimism that the international law produces to sort of increase public health expenditures.
I think there's a huge number of things wrapped up in there.
I hope I made some sense. I mean, that's what.
Yeah, I'm going to unpick them slowly. I think fundamentally, we have an obligation in international law and various commitments that we've made to guarantee people that right to health. As I set out, it's in the WHO's constitution, it's set out in other international agreements. The right to health is fundamental, and it's the highest attainable level. Obviously, we're not going to keep people alive forever. We all have health issues and we will all experience decline, but it's the highest attainable standard. And that attainability provision is partly where some of the issues you're talking about access to healthcare, about access to adequate nutrition, and all of these things derive. So we know that states have an obligation to strive towards delivering what they can, but there also is significant resource poverty in many jurisdictions. So I'm very careful as somebody in the privileged situation of a high income country not to say what you should do in the situation that you may face in your area of India, for example. I think there's a lot of collaboration opportunity there to talk about delivering international agreements, international codes of conduct and practice, which connects to one of the issues you raised there about healthcare workers, right? We know that one of the major limitations in low and middle income countries in delivering sufficient health and social care is the international recruitment of healthcare workers and social care workers. We go here in the UK, around the world, we recruit nurses from the Philippines, we recruit public health workers from India, we bring them here to the National Health Service, we exploit them as a resource, and we leave their communities without trained people to serve them. That is absolutely a problem, and international codes of conduct agreements under the WHO around that, and national government commitments to codes of practice and conduct on the recruitment of international staff are absolutely critical to ensure you have things like skilled birth attendants in India, to having public health specialists, nurses, etc. And so I think that is the place where we can make meaningful differences through having international codes that require the technical assistance as well as the expertise and evidence from public health to inform what we do. And that's really where I see the place of international bodies like the WHO as critical to the future here. And what's really important to unpick there is that one of the things you said really harks for me, because I hear it a lot, which is my country has a problem. We don't have enough calories. We don't have enough nutrients. And I would say to you, that is not true of India. It's the two sides of the same coin, right? Malnutrition is the other side of the coin of overnutrition. India has a problem with obesity and type 2 diabetes. India, like many countries, so this is not a unique situation, this is in fact replicated around the world, has a plethora of empty calories that are being pushed on populations by high sugar sweetened beverages being pushed, high trans fat dense foods, the creation of food environments that leave some people in one household obese. Often boy children are obese in the same household where there is a malnourished, undernourished girl who is not receiving enough calories. And this is highly gendered, to be fair, in many countries. We see this when we look at gender in public health data.
Dr. Steele, if I may interrupt, I mean, does this data has class, the social class in which these obesity groups are, that data might have... So
that varies between low and middle income countries, and also there's cultural and social norm actors. What we know is that in the UK, for example, overweight and obesity are a consequence of poverty. It's cheaper to get high calorie, low nutrient dense foods. Absolutely, that is not replicated in many low income countries where poverty equals no food or low ability to access food. So it is diverse, it is country, and it's almost, to be quite fair to you, it's locally specific within countries. So there is an intersection between class in many respects. There's an intersection with ethnicity and group and community identification and gender here. So as I said, even within a household, you can see a malnourished girl next to an overnourished boy because of gender norms. Within a community, you can see the very poorest members unable to access food, while the person living just down the road for them is morbidly obese. We see these things. And what I'm saying is there is a certain perversity to the allocation of calories as it stands. Here in Europe, and I'm going to speak collectively of the region, we have an excess of calories per capita. We have way more than any of us could ever need, while we see the MENA region and we see other parts of the world with insufficient calories. We clearly have supply chain issues, and we clearly have issues when we need to talk about our food environments. But what I want to say is part of that discussion has to also be about our regulatory environments, because it is in the commercial interests of many multinational corporations to sell as many calories as they can, because their products are the calories. They need to sell, they need to make profits, they need to make those profits for their shareholder. It's their imperative, it's what they're supposed to do. And trade liberalization regimes have facilitated the spread of those calories around the world to create a double burden of disease in many countries, especially your own. We see obesity, we see diabetes, we see these things that flow from excess calories alongside the challenges for countries of malnutrition, a lack of healthcare professionals. The politics of plenty are overlaid with the politics of the few who don't have access. And so you face this kind of double burden of not being able to address that unless we create capacity, unless we create a regulatory environment at provincial and national levels that allows meaningful public health interventions on both those fronts to grant access, but also to take action to address the issues of plenty. We're not going to get this under wraps. We're not going to fix this problem. Overconsumption is as much a problem as not having. And I think a lot of the conversations around COVID have highlighted that we can't ignore NCDs. The major risk factors for poor COVID outcomes, for hospitalization, for burden on governments, the major risk factors were not just aging, which was a major focus point, right? It was also obesity. It was also having type 2 diabetes. It was having previous chronic pulmonary disorders if you live in areas with significant air pollution. And those things are all things that law and governance can help with.
Thank you for your response. I think there's a question by our colleague, Dr. Neeraj Gupta. He asked a question: how do you see the role of these corporate giants involved in fast food business in this context? It speaks to some of your concerns that you're raising. Do they need to be more socially responsible to ensure global health as well as pollution, as their products are generally found to be in excess of the prescribed limits? And then the production process also leads to pollution, which is again a serious threat to health.
I think, to be honest with you, I am somebody who has heard a lot about public-private partnerships. We spend a lot of time talking about the fact that these big multinational corporations need to have a seat at the table. And I think that oftentimes they shouldn't. I personally think there's been a lot of access by big multinationals, especially, to policymakers and legislators that has had that chilling effect, which is deeply problematic. I am a proponent, though, of transparency and openness. I think there's absolutely times and places we should be making sure that products are safe. So we need to have industry collaborating to look at product safety. They need to provide us with data and information. But should they be at the table of a discussion over the regulation of their own product, where they have a very clear interest in it not being regulated? Should they be funding national science entities? Lots of governments have moved away from funding universities directly to allow independent public health research, independent legal analysis. And now researchers are contingent on industry funding to be able to do their research and have their teams and have their lab space or have their clinical school staff and things like that. I think there's fundamental questions for all of us about the need to have an international agreement on the involvement and also some funding that allows that technical assistance and cross knowledge, that fertilization across countries of what we know and respond to feed into that evidence for these kinds of moments of arbitration. If we don't have international researchers sharing the knowledge, if we don't have that being independent knowledge that's not just coerced by industry funding of the research, then we're not going to have good evidence. One thing we do know is that multinational corporations have put a huge amount of money into the rhetoric of energy balance. They have funded extensively regimes that suggest that physical activity is the solution to obesity when all of the science says it's a very, very small part of that picture. I want to be clear. Physical activity is really important to improve well-being, to reduce risk of stroke and things like that. It does have benefits. Physical activity is important, don't get me wrong, but it's not the solution to type 2 diabetes and it's not the solution to obesity itself. So multinational corporations funding huge amounts of energy balance rhetoric around the world and pushing governments to do things like put school activity programs where kids take 5, 10, 15 minutes to exercise in school during the day. That's not going to solve pediatric obesity. India is not going to suddenly have the perfectly calibrated weight for its children by doing 10 minutes of exercise once a day in school. It's not going to solve your problem. What is going to solve the problem is high-level discussions about how food systems should be configured, about what's appropriate to advertise and provide to children. As the United Nations pushes, for example, for school meals being universal by 2030 for all children, how is that going to be funded? How are we going to make sure those meals are healthful as well as culturally appropriate? How are we going to make sure they're not just co-opted and governments don't just pass this out to multinational actors, where the food plates of Indian children end up being a Coca-Cola or a high sugar sweet beverage next to a burger, like what happened in the US, for example. If you've seen the composition of many United States school meals, when I was a student, so I went to school in the US, and we got like burgers, and the ketchup on the burger was considered to be part of our fruits and vegetables for the day. Your tomato serve with the sugar sweetened ketchup they squirted onto the burger, and that was our fruit or vegetable serving. Like, we don't want that for the future. We want to create empowered governments with technical knowledge sharing as we form these coalitions. So the UN School Meals Coalition for me is a prime example of where we can create collaboration. We can draw on knowledge across countries from our experts, wherever they are. But we also need to make sure that industry doesn't coerce or influence that process of these meals in a way that make our kids less healthy. And we need to have robust international safeguards built into this process to make open and transparent any influence, to create those collaborative and technical assistance capacities. And we need somebody to fund this. And of course, the WHO is a well-placed institution to do that. At the time when we're debating its reform, do we want to put school meals with UNICEF? Do we want to put them with the WHO? These are the kinds of discussions I think we need to have, and law and governance capacity has a role within that.
One of my faculty colleagues, Taruna Jakar, has a question. She says, being a developing nation and also a generic drug supplier to least developing nations, how do we ensure technology transfer from developed nations to enhance our pharmaceutical research? Though TRIPS provided for it, but far from being implemented. So that's a comment and a question.
Yeah, I think that is absolutely true. I think that knowledge sharing and technical assistance are big issues for the future. COVID has proven that, right? Like, it's all well and good to create a TRIPS waiver. It's all well and good to say that you're going to suspend application of your domestic intellectual property, or to forge a contractual provision where a pharmaceutical company agrees to share its knowledge openly. But that doesn't matter if you can't manufacture it in your country because you don't have that capacity. And it doesn't matter if you don't have the underlying infrastructure also. So there's been a lot of these discussions of substantive international legal waivers to existing intellectual property regimes. And I think one of the things that I'm very conscious of is that I think that knowledge sharing is critical. And I think that that cannot happen just in an organic kind of way. Countries have acted in a way that has been in their national interest. They have become, in my opinion, many high-income countries especially have become insular. While that oscillates based on who you have in charge of a country, like who the government is, like we've seen a huge difference between, example, Presidents Obama, Trump, and Biden in terms of their willingness to work with other countries, especially low-income countries. That variability shouldn't be impacting on access to health for all. If we've committed as an international community in our international legal documents that we will try and attain the highest level of health and mental health and social well-being for everybody on this planet, then we need to create intellectual property regimes that actually work to do that. And so I think we're at a critical point for looking at how knowledge sharing, capacity building can be done alongside creating a regime that isn't as burdensome in terms of access to medicines.
That's
so
what
yes,
actually,
I agree and
that's
comment.
what actually Bill Gates
to
said. No, that's what actually Bill Gates said. No,
Yeah.
in terms of not having a copyright, and he said that some countries in the world would not have that kind of standard for manufacturing some of these drugs. So
and I think that's not a basis for saying no. I think India is one of the major drug manufacturers in the world, right? You all make most of the medicines for the rest of the planet. That's both a good thing for your economy, but it's also a massive problem for those in many sub-Saharan African countries right now, where they don't have access to vaccines at the level that they should because they're reliant on contracts and all of these things that have deprived them. While people like me have had 3 doses of a vaccine, many of my colleagues that I teach global health law with haven't even had one. And so one of the things that kind of sits there for me is that thinking about the international production base for medicines is absolutely something we need to do, but that involves us building capacity, building expertise, creating infrastructure support, sharing knowledge, sharing not just the patent, if that makes sense. The patent is part of this, absolutely, it's a puzzle piece, but it's not the whole picture. And so I absolutely agree that we need to be talking more widely than just TRIPS reform.
One of our students, Dia Shekhawat, is a question. She says, since we are talking about FCTC, there has been a lot of discussions about lack of implementation of FCTC's tobacco tax provision. Do you think implementing high taxes on tobacco is helping to reduce tobacco uses? Do you think that
the data say yes? I can answer that one straight out the gate. The data from countries with implementation is yes, high taxes. People are price sensitive. Sorry, but all the public health shows this. If something is expensive, people consume less of it. People are price sensitive. And we see that play out importantly also where sugar sweetened beverage taxes and alcohol taxes have been put in place. People are price sensitive.
Second part of the question is, do you think that having a blanket ban on the use of it is a solution as well? Sorry,
on the use of?
Tobacco.
Tobacco. So I think there's a really interesting situation emerging in New Zealand where they're prohibiting it by age. So I don't know if you've all seen this, when the New Zealand government has legislated for certain people born in a certain year will no longer be able to buy tobacco. So everybody born after that date will not be able to buy tobacco products. I think the success of provisions like that is contingent on an enforcement, but also contingent hugely on the illicit trade. One thing that we know is that crimes around illicit goods, especially dangerous goods like tobacco, are numerous and require commitment and cross-border commitment to respond. The illicit trade in tobacco requires us to have robust economic crime responses and requires us to have robust responses to a wide range of offences and things. I mean, the international illicit trade in tobacco is deeply connected to something else I work on, which is modern slavery and human trafficking. These things are all intertwined, economic crime, these kinds of things. If we don't have robust international responses to that and to have collaboration and inter-country cooperation from the enforcement end, also to make sure we have adequate domestic legislation to be able to work together, we are never going to overcome this and completely eradicate tobacco use. The other thing that sits here is a big debate. So the status of where evidence is on things like vaping, so electronic cigarettes as an alternative to flammable tobacco. The WHO has a clear statement that it believes that e-cigarettes and the nicotine-based are a problem, that they are a segue to take up smoking amongst younger people rather than a tobacco reduction strategy like has been put forward by people like the Gates Foundation, for example, that explore that as an option for a tobacco-free world. I think the state of evidence requires robust scientific knowledge, and it's why I work with public health colleagues and clinical colleagues and biomedical scientists. So I think a huge part of this is about developing knowledge, developing an evidence base and guiding us towards that. And I think a tobacco-free world probably requires us to, as lawyers, to appreciate everything from criminal to trade law to health law to economic crime provisions around evidence and procedure. It requires us to have a good, diverse knowledge. And that's one of the things that I found is that so many of us specialize very quickly. We're encouraged to kind of focus ourselves in, and I think that absolutely benefits us, but having a generalist knowledge is hugely useful. And lawyers are very good at getting some of that generalist knowledge. I think what I'm saying though is that health law should be within that scheme.
So the next question is from our faculty colleague, Sukrit Garg. It's a question and a comment, and this relates to some of the discussions that we had on life choices and the regulatory environment. So it's related to that. The non-communicable diseases are noted to be the primary call to death. We saw that most of these diseases are cardiovascular, respiratory, or others like diabetes. These health issues are related to development, urbanization, and the modern lifestyle. The goals of our socio-economic life seem to be antithetical to the health goals, which we should have had. How do you think can we ensure that health goals are included with some dignity in our socio-economic goals? Also, often health goals are dictated to be more personal in nature rather than something that institutions should also be careful about? How do we have institutions meaningfully acknowledge health goals? And I think it's both about domestic institutions and international institutions.
Yeah. I think it's partly having a robust obligation on states to meaningfully implement. I think at the moment, we see health as a human right in that kind of very wide way. And now we need to trickle that down into creating substantive requirements in trade law, into requiring substantive obligations for countries to implement and provide access. But we can't just go into some countries somewhere in the world and say, you shall deliver universal health care. They don't have the capacity to, they don't have the money to, as you've said. So this involves us acting as an international community to kind of do that capacity building, to do that knowledge sharing, to invest in other countries and not just look at our own. That's not saying we don't look at our own, that's saying not just. I think the really important thing there is saying you have to deal with your own citizens, but you also need to see yourself as part of an international community. And I don't think we can avoid the human right to health as a planetary issue for much longer. Climate change is going to make planetary health and food systems critical issues. As we see climate change happening, what foods we have available is going to shift. A simple frost overnight in one part of the world can ruin the supply of a crop to multiple countries and fundamentally shift what's in somebody's diet. One night of a snap frost with a heated period afterwards could stop a whole crop from being produced in an area. I mean, that realization that this is happening now in certain parts of the world where whole crop failures have doomed us to shortages. I mean, I can say this in a way as an Australian, we're all addicted to avocados a lot. And like one early frost ruined most of the world's avocado supply a couple of years ago. Absolutely, the avocado is a luxury good for me, and it's certainly not native to my own country. But that proof point of just how much our diets can be impacted by climate change, I think necessitates an international response. And it's going to be more pressing. If we don't do it now under the conditions of post-pandemic, we absolutely will be doing this when climate change hits us hard. Not that it's not already, but it's going to hit us harder, and we're going to have to do it. I would like an ideal world where lawyers take part in these discussions because we want to be central to driving a world where we have health for all, rather than us being drawn in when we're in crisis and everybody's panicking going, what can we do? Help now, help. I would much rather us upskill collaboratively, organically now, than have us being the panic response like we saw many lawyers being brought in when we realized we weren't going to have a vaccine in time. Suddenly public health lawyers became really important. We suddenly saw a public health, do we have enough of them? And some places didn't have enough of us. They didn't know what they were doing. They were trying to get the expertise on the spot. And I think that's really important. It's about training, it's about change, it's about planning, and it's about commitment. And I think that commitment comes from all of us pushing for robust institutional change at all levels, from local government to national government to international.
Okay, one last question. There are many questions, but we'll take this question before we come close to the session. One of our faculty colleagues, Neeraj Sharma, says, ask for your comments on how to regulate use of plastic in food packaging, as it is a potential health hazard, especially for poor in developing nations.
Yeah, I think one of the things that sits here with food systems is that we need robust implementation of substantive change, both in terms of waste and also other forms of invisible waste. So plastic is something that's highly visible, but there's also other inefficiencies in supply chain that are environmentally degradous too, that create chemical waste and offput. The overuse of antibiotics in agriculture is a major issue around the world at antibiotic resistance. So antimicrobial resistance is going to require us to take different supply chain approaches as well. So I think the thing here is we could just have an agreement on plastics. It's not going to fix our food system and pollution problems. Plastics are part of it. They're highly visible and they've received a lot of attention, and I agree they are an issue. but they feel to me like a little bit of what I'll call low-hanging fruit. They're an easy one to pick off. What we could do is robustly attend to having sustainable food systems, reducing corruption and waste, and addressing some of the other issues of things like, example, that we lose a huge amount of agricultural produce due to corruption in the supply chain. Much of it is wasted. Large amounts of food are burned or distributed in inefficient ways that lead to wastage. We have large amounts of plastic waste and other packaging waste. We have large amounts of other things built into this system, and more accountable technological solutions can kind of sit alongside that. I'm seeing some really interesting things around blockchain and agricultural systems to try and address these sorts of things and reduce the need to package in that way. But I'm also seeing that we need to have agreement, and we need to have consistency, and we need to have knowledge sharing. We need to know what works in different places. The World Bank's had some really interesting projects on this, just to say, but they also require us to look at how we regulate technology. So there's a lot of AI solutions to supply chain issues, and that connects to our intellectual property issues here. We're not sharing those technologies. They're owned by private companies, and they're out of the reach of many in developing settings. We have a lot of options. I think we just have also a lot of people retaining things for profit or keeping them in their own national interest, and sharing and collaboration are key.
So I am hard pressed to ask two more questions because your discussion has provoked it. One question that I'll pose, I mean, I'm just thinking about, you talked about so much about human rights and its relation with global health and international law. I just want to know that whether it provides some kind of support to refugees and migrants also. I mean, what's the position? Yeah.
Absolutely. I think conflict and displacement are major issues in global health law and government. They're not something I've addressed today. It's been outside the bounds of it just because of time and the fact that they're complex. We know that there is substantial places in human rights law for ensuring access to healthcare for displaced persons. There's a huge scope for attending to the unique needs of migrant communities, of different communities in conflict, that communicable disease flourishes in conflict situations, malnutrition also flourishes in these situations, and that human rights obligations place a requirement on us to provide health for all, and that includes these people that may be stateless at the time. I don't think we've done enough. I think we're trying. I don't think we're there. I think this is all part of it. And I think that a robust, more holistic approach to global health governments that connects global health and human rights in a meaningful and applied way with technical assistance and collaboration at the heart, rather than competition and border control and you shan't cross the English Channel and come here and claim asylum. And maybe I'm just the person who hopes we'll hold hands and collaborate a little bit more, but I think the current planetary situation and the inevitable amount of climate displacement that is going to follow with that necessitate that we actually take this into account. If we don't do this now around conflict communities and communities who are displaced, and we don't robustly start to address their healthcare needs as well as building preventative health in displacement, we're going to have a situation where we just have to do this when we've got a climate crisis. So now is kind of the time to do this human rights work, both in a very applied way, but also making sure that it's nutted out and institutionally created through legal capacity building and through legal institutional frameworks that create the normative as well as the substantive basis for action.
Okay, this is really the last question, and this is a question posed to you by our Dean, Dr. Madhuri Parikh. She asks, what are the issues related to leadership in global health governance?
Diversity would be my first one. It's very, sorry, I'm going to say it. It's largely a lot of the influence in international health law and global health law to date. If you go to high level things, is very male, is often very white, is often very high income country. So one of the things that I would say is I think one of the huge things we need to see is diverse voices in global health governance and law. We need to see global health lawyers who come from all different countries, all different backgrounds, from different classes, who have different gender identities, who have different life experiences, and embrace that diversity to have more representation at the table. I think we also need to have global governance structures that look at what institutions have the best capacity to orient this. We often try collaborations and partnerships. We have a language of partnerships, which I think is important. I am obviously somebody who's a proponent of collaboration, but one thing that can do is just lead to everybody having an opinion and nobody taking action. And so creating institutions at the international level that both monitor and evaluate and draw together evidence to knowledge share is really critical. Whether the World Health Organization is that body is highly debated. I think it can be. I think we're at a point of institutional change as well as legal change in terms of where we want to go with a pandemic treaty and where we want to go with things like that. I think now is a critical time. If we capitalize on this opportunity to ask, what do we need to have the highest attainable levels of health for all? What do we need to do? We can do that. But we need to have that discussion, and it needs to not just be me as a privileged white person in a first world nation at an incredibly privileged university saying that. Because what I say and what many of your students would say, and then what many of my other students who've come, that I've had this conversation with last week in a different setting, who come from Lesotho and Nigeria and Uganda, their positions are so different than mine and their needs are so different than mine. And my Jamaican dissertation student at the moment has a different perspective. Having those different views, raising those different issues, talking about what institutional capacity building is needed in different nations, and thinking about the ways we can facilitate that could lead to a better international legal response. I don't want to give you the answer. I want you to ask everybody that question.
Madhuri, madam, if you want to say
thank you so much. Thank you so much. It's a so thought-provoking session. I enjoyed a lot. Thank you so much being with us.
Thank you so much for having me.
So,
right.
Yeah.
I am more than happy to receive more questions at another point. I must be off because I have people coming in 7 minutes, including a member of parliament today, so I need to run. It was wonderful getting to talk to you all and receiving your questions. My email address .
So thank you, Dr. Steele, to be here on the behalf of Institute of Law. We thank you, and we have been extremely delighted to have you here. Thank you for such a wonderful session. Thank you so much for being here.
Thank you. Bye all.
Thank you, Dr. Steele.
Thank
Bye.
you. Bye.
Bye-bye.